Welcome back to Winning Law. I'm attorney David Nguyen with offices in Houston, Texas. Today we're going to discuss USCIS Form N-600, Application for Certificate of Citizenship. This form can be filed for two main reasons. First, you can file it if you were born outside of the United States to a U.S. citizen parent and you believe you are already a U.S. citizen by birth. Secondly, you can file this form if you believe that you automatically became a U.S. citizen because one of your parents became a U.S. citizen before you turned 18 years old. The problem with this form is that it looks very easy to complete because it's only a few pages. However, you will be surprised to know that if you file this form and the case is denied, you will never be able to reapply. Yes, you heard me correctly. According to immigration regulations, once an N-600 application is filed and denied, it cannot be refiled. This is true even if immigration issued a request for evidence asking for simple documents from you and you did not receive it. This is also true if you found more evidence to support your claim of citizenship later on. Also, this is true even if you filed the case yourself and the second time you want to use an immigration attorney. In all of these situations, you cannot refile. As you can see, even the best immigration attorney in the entire world cannot help you refile a previously denied N-600 application. The very best advice that I can give someone that is considering filing an N-600 application is to use an experienced immigration attorney. If you file the N-600 application by yourself or you use an attorney that's inexperienced, your case may and probably will be denied, and you will never be able to obtain a certificate of citizenship ever again. So what should you do if you want to file an N-600 application, but you simply cannot afford to hire an experienced immigration attorney, or you already applied for the N-600 and it was denied? In these types of situations, I would recommend applying for a U.S. passport instead. A U.S. passport would also evidence that you are a U.S. citizen, and you can apply as many times as you want, as long as you pay the fees. The only problem with applying for a U.S. passport is that the government is going to require you to provide the same types of proofs and evidences that you had to submit with your N-600 application. So this means that if you could not convince immigration to give you a certificate of citizenship, most likely you're not going to be able to convince the U.S. passport of the same thing. Remember, U.S. immigration laws are complex, and more often than not, you will fare much better when you have an experienced immigration attorney. So again, thank you for watching Winning Law. I'm attorney David Nguyen, and we hope that we have made immigration easier to understand.
At David Nguyen's Law Office, we are here to help you. We bring families together through immigration. And on the other hand, we help you find solutions. All your legal needs in the hands of people who care, who are there for you. We'll take care of your loved ones at the law office of David Nguyen.